My dear friends, we have traveled from different parts of the country to attend this national convention. I am very happy to be in your midst today evening to deliver my inaugural address on an important topic which is chosen by All India Lawyers Union in the capital city, New Delhi, namely the Save Constitution, Save Democracy. Friends from print media and electronic media, ladies and gentlemen. Save Constitution, Save Democracy is a very, very important topic which is required to be debated day in and day out in India today. Constitution, as Ambedkar put it, Constitution was a great revolution based on equality code in a society whose DNA was essentially social inequality. Liberty, equality, and fraternity are the basic structure of the Constitution of India as per 13-judge Constitution bench in Keshavananda Bharati's case way back in 1973 by the Honorable Supreme Court of India. Liberty, equality, and fraternity, this trinity is the three pillars of democracy which Indian Constitution assured Indian citizens. During the last 8 years, these very values are endangered because of the ascendance of right reactionary forces in the society and the very democratic state transforming into a fascist Hindu state. All the democratic institutions are either taken over by these forces. For example, the CAA, the Citizen Amendment Act, NPR, and NRC essentially denies equal citizenship, which is the bedrock of secular Republic India. The minority religion is frightened in this country today. The Ayodhya judgment has made the right reactionary forces, despite the law enacted by the parliament way back in 1981, made to claim Ganwapi mosque and other mosques in the country. This is a threat, great threat to the Republic India, where multi-religion country, there is no concept of majority and minority religion in the Constitution. The reading down of Article 370, fiscal coercion of states through cess regime, reducing the office of governor to function not impartially, make the duly elected governments in the federal feature of the Constitution. The federal feature of the Constitution in India, way back, a historical judgment rendered by the Supreme Court of India in the year 1984, S.R. Bommai versus Union of India, held the federal feature of the Constitution is the basic structure of the Constitution. Despite the law laid down by the Supreme Court in Bommai's case, the central government I don't want to use the word central government, Union of India, Parliament has enacted the law in relation to the NEP, where the concept of NEP disturbs the fabric of federal future of the Constitution, EIA, demonetization. The Constitutional Bench of the Supreme Court of India very recently pronounced the judgment on 3rd. Minority view is the due process has not been followed by the Union of India. The Reserve Bank of India required to exercise its statutory power under Section 26(2) of the Reserve Bank of India Act. But on the other hand, the Union of India directed the Reserve Bank of India to pass the resolution for demonetization. The lonely judge had the courage and conviction to uphold the constitutional democracy in this country. Demonetization has made the people to suffer and died more than 250 persons. During the pandemic, Corona, 3 years back, lockdown was imposed without giving reasonable time for the state governments and the people of this country to prepare to face the pandemic of Corona. On account of clamping of the lockdown, the small-scale industries and the industries were affected to the larger extent. The economy of this country has crumbled down. The progress and development of the country has come to standstill. An independent India, under the Constitution, which is a vibrant constitution in the world, that envisages the independent supervisors over the executive, like CAG, Election Commission, etc., has become expanded organ of the Union of India. Supreme Court again and again, interpreting Article 324 of the Constitution of India, has laid down the law, constitutional benches after constitutional benches. Fair and free elections must be conducted. The recent fast for the last 1 decade or 8 years, either in Gujarat elections, Uttar Pradesh elections, or Bihar state, we don't find fair and free elections are held, which are very important for the democratic parliamentary democracy in this great India. Elections have become the rituals to legitimize the right reactionary forces to come to the power, which we are noticing. This democratic decay has resulted in immense social and economical crisis to Dalits, who constitute 20% of the population of this great country. The Muslims have got fear psychosis for their existence in this country. While India has increased number of billionaires, even during COVID, its population below poverty line has swelled by 6.5 crores. That apart, though EWS, economically weaker section of the society, by constitutional, blatant violation of the preamble of the Constitution of India, and the conceptual idea of the Constitution, which has been embedded in the preamble of the Constitution, the socialist achieve the egalitarian system of society, to eradicate the inequality, to render justice to the oppressed and suppressed class of the society, namely the scheduled caste, scheduled tribe, and backward classes. Articles 15 and 16. 15 envisages a reservation in education institutions. 16, reservation to the scheduled caste, scheduled tribe, and backward classes who are socially, educationally backward, ignoring this conceptual idea which has been recognized by the Supreme Court and the Constitution, Article 15 and 16, systematically they have enacted the law. The constitutional validity of this law, constitutional validity of the amendment to the Constitution 15, 6 and 16 say, has been upheld by 3:2 judges of the Supreme Court of India. 2 judges, the former Chief Justice and another puisne judge, have held that this is blatant violation of Article 15 and 16 and 14 of the Constitution of India. The way in which the Parliament is introducing the bills and amending the constitutional amendment, and also the law in relation to the farmers, you must have seen more than a year, farmers were on strike. The amendments to the Land Reforms Law, Agriculture Produce Marketing Act, giving a big hand to the multinationals and big traders, big corporate sector, notwithstanding the prohibition under the Land Reforms Law, they have been given the floodgate opened to purchase the agricultural land in different parts of the country, to see that the agriculturist must suffer. This is again opposed to the constitutional concept which has been recognized by the Supreme Court in number of judgments of the constitutional benches. My dear friends, time is very short. I have prepared a text of my speech. Normally, I will not prepare the speech. I am an extempore speaker. To minimize my speech and to adhere to the time which is given to me, I have prepared the text. I will quickly present to you. The Annual Democracy Report of 2018, the University of Gothenburg has stated thus: in India, the infringements on media freedom and civil society activities of democracy following the election of a Hindu nationalist government have started to undermine the longest standing and most populous democracy in the global south. While there are about 12,000 newspapers circulating in India today, the media is increasingly being censored. Several newly introduced or more harshly enforced laws hinder free speech, encourage censorship. Many journalists in India have been killed or threatened for reporting critically on the actions of the ruling party. 3 journalists were killed in March 2018 alone. For example, the editor Gauri Lankesh from my state, Bangalore, who was a known feminist and critic of the caste system, as well as the right reactionary forces, was shot dead in September 2017. journalist Siddiq Kapan has already spent more than 2 years in jail. Very recently, he has been enlarged. The Supreme Court, in the case of another journalist from Bombay, bail was granted notwithstanding the fact that bail petition was pending before the Bombay High Court, whereas in the case of Kapan, Siddiq Kapan, petition was filed before the Supreme Court, matter was not taken up by the Supreme Court. When the matter reached before the Supreme Court has asked him to go back to the High Court of Allahabad. Ultimately, he got the bail. He has been detained for more than 2 years. His liberty has been curtailed because the case was registered against him under the provisions of the UPA. Supreme Court has interpreted, 3-judge bench, grant of bail is a fundamental right guaranteed under Article 19, notwithstanding the provisions of the UPA Act. So 2 years for no fault, in the sense case may go on for trial, but a person who is a journalist who went to the Uttar Pradesh to report a rape and murdered Dalit lady case, he has been arrested and detained in the jail. India is also now on the 150th position in the World Press Freedom Index. As per its 2022 report, the index indicated a steady decline in press freedom in India in the past few years. What is concerning the nature of the index is the narrowing distance between India and countries with dictatorship and authoritarian governments. The countries which normally occupy the bottom of the index, such as Saudi Arabia, North Korea, Myanmar, etc., are infamous for ruthless dictatorship, human rights violations, and absolute disregard for any democratic values. The media is used as a propaganda apparatus or as a branch of the government in these countries. An independent press does not exist in these countries, where the media is either owned by the regime or people who are close to the regime. India's recent performance in many of the global indexes related to independent media and press freedom show tendencies that are not opposite for largest democracy in the world. This sharp decline reveals a dangerous state of affairs in the functioning of media and democracy in India. The condition of the press in India is more often attributed to the vulnerabilities of Indian democracy and the attitude of the political leadership. The celebrated diversity in the media landscape in India never translated into a free and independent media ecosystem. The silence of the civil society organs is the most worrying factor in this regard, especially the political parties, academia, social activists, and the big media enterprises have never questioned or discussed the conditions which have led to the weakening of the press freedom in India. Indian democracy has been experiencing a turbulent situation in recent decades. This has undoubtedly affected the media in the country. However, the lack of meaningful discussions about the condition of media remained a constant phenomenon during the past decades. Silence of the civil society on media freedom has compromised the role media can play in a democracy like India. The media's political bias or absence of independent journalism never attracted any response from any sections of civil society. Blatant political bias and association with the feudal and religious forces define the nature of civil society in India in contemporary times. This could be the primary reason behind the indifference of the sections of civil society to the erosion of democratic institutions like media in the country. The autocratization process in India has led to partial closing of the space for civil society. The government increasingly restricts the entry and exit of civil organizations by using law on foreign funding for NGOs. The Foreign Contributions Regulation Act, FCRA, as in 2017, 20,000 NGOs, mainly working on human rights and environmental issues, have lost their licenses. After that, only 13,000 NGOs remain to continue working unconstrained. In 2020, Amnesty International India was forced to wind up operations in the country after its bank accounts were frozen by the Enforcement Directorate. 3 UN special rapporteurs have urged Prime Minister of the country to repeal the FCRA, claiming it is progressively used more to silence organizations involved in advocating civil, political, economic, social, environmental, or cultural priorities, which may differ from those backed by the government. The Human Rights Council, United Nations Human Rights Council, its chief has warned India that its devised policies could undermine economic growth, saying that narrow political agendas were marginalizing vulnerable people in an already unequal society. We are receiving reports that indicate increasing harassment and targeting of minorities. In particular, Muslims and people from historically disadvantaged and marginalized groups such as Dalits and Adivasis. Michael Bachelet said in our annual report to the United Nations Human Rights Council in Geneva. India 2021 Human Rights Report, United States Department of State, it has stated, there were reports that the government or its agents committed arbitrary unlawful killings, including extrajudicial killings of suspected criminals and terrorists. According to the prison statistics of 2020 report released in December, there were 1,306 prisons in the country with a total authorized capacity 4,14,333 persons. The actual incarcerated population was 4,88,511. Persons awaiting trial accounted for approximately 76% of the prison population. The law requires detention of juveniles in rehabilitative facilities. But at times, authorities detained juveniles in adult prisons, especially in rural areas. Authorities often held pre-trial detainees with convicted prisoners. The PSI 2020 report acknowledged overcrowding as one of the biggest problems faced by the prison inmates. There were reports from journalists and NGOs that government officials at both the local and national levels were involved in intimidating critical media outlets through physical harassment and attacks, pressurizing owners, targeting sponsors, encouraging frivolous lawsuits, and some areas blocking communication services such as mobile telephones and the internet and constraining freedom of movement. The report noted that India had been downgraded from free to partly free, and the said government had blocked the Twitter accounts of several journalists who had covered the farmers' protest last year. The Reports Without Borders was also cited as describing India as a very dangerous for journalists. As of today, there is no institution left in the country which has not been interfered with in the last 8 years. The line of succession in armed forces has been meddled with. Then Lieutenant General Bipin Rawat was appointed as the Army Chief in 2017, superseding 2 senior officers. 2 RBI governors, Urjit Patel and Raghuram Rajan, were forced to resign after undue government interference in the working of the Reserve Bank of India. The recent war between the top 2 officers of the CBI also appeared to be internal spat, but was actually a direct result of the government, Union of India, appointing favored nominee Alok Kumar as the director in January 2017, and then putting his back up by inserting another favorite, Rakesh Asthana, as his number 2. After the Verma Asthana fight came out in open, the government arbitrarily and perhaps illegally sent both of them on leave and superseded the incumbent number 3 officer. The Election Commission is another constitutional body that appears to have buckled under the government pressure. Going by media reports, at least 2 instances of flagrant partisanship have been displayed by the Election Commission in India. One was its decision to delay the announcement of Gujarat polls scheduled in 2017, allegedly to allow the Prime Minister his party continued distributing largesse in the state. And 2, hurried and unseemly disqualification Aam Aadmi Party MLAs from Delhi on the office of profit charges, after which the Supreme Court rejected the EC's decision and castigated it for not looking at the whole thing more thoroughly. The Election Commission has thus for not displayed publicly at least any resistance to government pressures. In a move to curb the use of Right to Information Act to expose government malfeasance, it has moved the amendments to the Act itself, which do away with the present 5-year fixed term for information commissioners, both at the Central Information Commission and State Information Commissions. The amendments also enable the Centre to prescribe the term of office, salaries, and other service conditions. In this case, the government has attempted to subvert the RTI Act and its machinery through pushing amendments, a legislative way of curbing transparency and accountability. In the process, the whole mechanism of information commissions will be made dependent on the government, further weakening it. The freedom of the press appears to be under attack as well, that I have already dealt with. Attacks on the judiciary and crumbling of the institution. The independence of the judiciary is the third limb of the Constitution. Judicial review is the basic structure of the Constitution of India. Way back in the year 92, the collegium system, after interpreting the provisions in the first Advocate Association case, laid down the law that was reiterated by 9-judge bench, Constitution bench, in the year 1999. The collegium system is in vogue. Collegium of the constitutional courts in the country, on their recommendation, the collegium of the Supreme Court is appointing the judges to the constitutional courts. To take away that power, in the year 2016, constitutional amendment was made, NJC. That was the challenge in the Supreme Court under Article 32 petition. 5 judges have sat and discussed heard the matter at length and examined the entire case law, particularly the independence of judiciary is the basic structure of the Constitution. Supreme Court, Constitutional Bench has held the amendment to the Constitution establishing the NJSC on various counts. It has been struck down from 2016 to 2022-23. The Parliament did not choose to enact the law or amend the Constitution. 2016 to 2022, the collegium system is functioning. I am not saying collegium system is perfect. I have got my reservation on certain aspects. I am only at the point that the constitutional authorities, when the collegium system is in force, is in vogue, they are following the procedure laid down in the judgments of the Supreme Court, which is binding on the constitutional authorities, the Union of India, the President, the Prime Minister, Council of Ministers, Chief Ministers, including the Chief Justice of India and the judges, everybody. The constitutional institution is functioning. They wanted to attack the judiciary in this forum. You must have read in the newspaper, the bench which was being presiding on this matter has came down very heavily. Asked the Solicitor General, Attorney General, we don't accept this kind of comment. So, yesterday you must have seen what statement they have made. So, I am on the point that in India, independence of judiciary, after the establishment of Supreme Court, no doubt the evolution of law right from the A.K. Gopalan's case, Champak Dorai Raju's case, 1973 Supreme Court is a historical judgment. S.R. Bommai's case is a historical judgment. Freedom of liberty and expression, fundamental right guaranteed. Maneka Gandhi's case, Indira Gandhi's case, Supreme Court has rendered historical judgments. Of course, in certain aspects, I have got my reservation. When the Supreme Court and the constitutional courts are there, recognized in the Constitution, when the constitutional amendment and the law that is enacted by either the Parliament or the state legislature can be looked into, judicial review is permissible. Judicial review is the basic structure of the Constitution. Whenever they are struck down, they make a comment, they make the criticism, they attack the judiciary. This is not acceptable for the lawyers at large. The judiciary and the Supreme Court are the last hope of the citizens in protecting them. But the track record of the Supreme Court is also in the last 8 years is disappointing. 370 article was repealed. Freedom of speech was curtailed in Jammu Kashmir. These, apart from this, the aspects, namely that what is called the corporate sector paying money to the political parties, is it justifiable or not? Yes. Electoral bonds. Cases are not taken up. These are all priorities. You have 370 constitutionally, repealing the constitutionally valid or not is not examined. And these are all very basic tenets which will affect the population of the country. You are not examining. And equal opportunity is not there for all other political parties. Political parties which are in power are getting money. They can't compete with the other political parties, some other political parties. Very important matter. Democracy, elect their true representatives. There must have, all stakeholders have equal opportunity. That is not there. Supreme Court is not taking up, not decided this matter. This is very, very bad. In 2014, Apex Court was not hesitant. I am also saying good things what Supreme Court has done up to 2014. Apex Court was not hesitant in going against the central executive in the matters involving high political stakes. This was evident in 2G licenses case, cancellation of the 2G licenses and coal scam cases. The Colgate case, of course, it was in the month of September. Hearing was taken place during the regime of UPA 2, during which the court passed several oral remarks, including the famous CBI remark, caged parrot, badly stinging the government. The intervention of the court drew a lot cheers from the media and public, which hailed judiciary as a crusader against corruption and misgovernance. But post 2014, the Supreme Court presented a meeker version, which I do not want to make further comment, which is known to everybody. The verdict in politically charged cases, such as Sahara Birla, Loya case, Bhima Koregain, Rafale, Aadhaar, etc., have invited lot of criticism of the public. So when it comes to taking on the system, court acts hesitant. Court has not yet adjudicated abrogation. I have already stated, Article 370. To conclude my inaugural address, the current trajectory of Indian politics reminds one eerily of the first decade of the existence of neighboring Pakistan and Afghanistan and other countries. So I am very happy that All India Lawyers Union, to which I was the founder member, I have got the opportunity to stand before you as a former judge of the Supreme Court to make some observations and to deliver my inaugural address. This is a national convention. Different parts of the country, eminent lawyers, senior lawyers, young and energetic lawyers who have assembled here. I must congratulate on behalf of the legal fraternity and population of this country that you have taken up the good cause, save democracy and save constitution, save democracy, which will not be concluded by one convention. This must go on continuously to protect the constitution and democracy. Then only we will have the fundamental rights guaranteed Part 3, directive principal rights guaranteed in Part 4, both constitute the human rights as held by the Supreme Court in Ketanaf cases. And to see that the Indian judiciary independence is protected, constitution is saved, democracy is saved, otherwise it will not be a civil society. Thank you very much for having given me the patient hearing.